We're so delighted that we get to discuss some of the contributions and to have some presentations by two of the authors today and to discuss their specific work. So just to provide a tiny bit of context about the book, this book follows the regulation of social media influences that was also edited by Catalina Gawanta, who is on the call but in a silent carriage on the train. So hi, Catalina, as well as Sophia Ranchados. And in this edited volume here, we're really extending this focus on how a social media influences regulated with a specific focus on labor and how we can begin to think about the cultural, economic, and legal dimensions of content creation as this particular form of labor. And I guess really speak to some of the discussions that are going on across different disciplines and how we characterize this labor. There's been a lot of work, particularly in creator studies, that has been addressing a lot of the unpaid activities of creators, developing different practices of labor in order to produce content and turning that into a monetizable prospect. And alongside this, we have the understanding of influencers as an economic enterprise, which brings with it, certain responsibilities and obligations. And so this is one of the things that the book was really interested in doing. How do we make sense of these kind of tensions between influencers as entrepreneurs who need to play by market rules and as individual laborers who, of course, are operating under the discretion of platforms. And so we in the collection have brought together I think 15 different authors who come from different disciplinary backgrounds to think about some of the theoretical underpinnings of influencer labor, some of the empirical strategies that are employed by influencers, and then the legal implications. And so the contributions that our webinar will center on today is taking this legal perspective and thinking about how to characterize what influencers do within particular legal regimes. And I might turn it over to Isabel now, who is also one of the co-editors of this project, to say a little bit about why influencer labor and thinking about influencers is really relevant and interesting from this labor law perspective.
Yes, thank you, Taylor, and thank you everybody for being here. I'm very happy that I could do this big book project with you all, and together with my co-editors. It was a lot of fun. It brings together our interest in social media influencing, and I have a special interest also at the university in labor. I think the two chapters that we're going to discuss today will show very well that there is a big employment or let's say work in its bigger sense perspective to it all. And I think it would be like that in every country. So it's not just in India or France, it's like that in Switzerland too. Since influencers have their living off their influencing activities, as we see very well in these two chapters, this has consequences when they're at the discretion of the platform, consequences where we have to ask, or the workers enough protected if the Twitch platform can cancel their account and their life depends on it, their monetary life. What consequences does that have? And I think I've looked at that question also in Switzerland. It's not just for influencers, of course. There is other workers that are not employees in the sense of a national law, and especially protected, that will have the same issues. But I think here we're looking at the influencers in particular, and there is interesting issues that arise, and that are talked about in the book, such as, for example, what happens when you lose your job, when the platform unilaterally cancels your account, or what kind of child protection is there, because the children in many countries are very strictly regulated how they can work in an employment contract, however, maybe not in a non-employment work contract. And I think these issues are interesting, and to look at them from the lenses of different countries, it's interesting. And yet there, I think this similar questions that will arise in many countries. So I'm happy to have you here and discuss these issues.
Thank you. Amazing. So now we'll dive into some of the specificities of what is discussed in the book through 2 chapters. And the way that we'll structure this is that we will hear from both authors, who will briefly introduce to us their chapter, and then we will hear two responses from 2 discussants about how they've reflected on this work before turning it into a discussion with all of us. So first I would like to introduce Laura Aade, who is a PhD candidate in consumer law and platform governance at the University of Luxembourg. And her chapter is entitled "To Ban or Not to Ban: Understanding the Impact of Platform Discretion in Content Moderation on Professional Twitch Streamers." So Laura, I'll hand it over to you.
Thank you so much. So just let me share my screen. Can you see my screen? Okay, great. So thank you so very much for being there. It's really a pleasure for me to be able to give you some insights on the chapter that I wrote. And this webinar also gives me the opportunity to thank once more the editors for putting together such a wonderful book, but also for the very useful comments that I received on the chapter. So as Taylor mentioned, my name is Laura. I am a PhD candidate at the University of Luxembourg. And so the research that I do in the context of my PhD is a little bit different from what I did in this book chapter. So the research I do on a daily basis in Luxembourg. So essentially, I look at the emergence of e-commerce on social media platforms and the role of consumer law in this specific context. But in this book chapter specifically, I've decided to do something a little bit different. And I decided to look at the impact of platform discretion in content moderation on professional Twitch streamers. So some of you perhaps might be familiar with Dr. Disrespect, who is one of the most well-known streamers in the gaming world. So he actually built a massive following thanks to his personality. But in June 2020, something unexpected happened because Twitch banned Dr. Disrespect without warning and without any explanation whatsoever. So this decision, of course, left the gaming community shocked, with fans and fellow streamers scrambling for answers. And Twitch, in response, issued a very vague statement saying, "We take appropriate action when we have evidence that a streamer has acted in violation of our community guidelines or terms of service." So in other words, they didn't give any explanation. And it's only recently that Dr. Disrespect himself shared the reason why he was banned, which was allegedly because he sent messages to a minor that leaned too much in the direction of being inappropriate. But I mean, Dr. Disrespect himself and its viewers had to wait 4 long years before really understanding the reason behind this ban. In this case, so the case of Dr. Disrespect is a very good example to illustrate the discretionary power that platforms have in content moderation. So because these platforms operate under their own terms and conditions, they essentially act as private regulators, making decisions that can impact millions of users without outside oversight. So they can remove content, they can ban users, they can even shut down entire revenue streams, all at their own discretion. And this is where things can get quite concerning for content creators and streamers, as Isabelle was mentioning, especially those who rely on platforms like Twitch for their income and who belong to one of the monetization programs offered by platforms. So now, so this chapter focuses on Twitch. And if we look at the monetization programs offered by Twitch, we have three different programs as we speak right now. So there is the affiliate program, there is the partner program, and there is the partner plus program. And so these programs essentially allow streamers to make money through different monetization schemes, so ads, subscriptions, or donations, for instance. What is nice with these programs is that they essentially provide some financial stability for creators, but of course they also come with a major risk, that is the risk of losing everything overnight. So if Twitch decides, for instance, to ban or demonetize a streamer, there is often no clear explanation, as we saw with a Dr. Disrespect, no meaningful way to appeal, and no real accountability on the platform side. So despite how common these issues are becoming, there is still a lot we don't fully understand about the harms caused by a platform discretion in content moderation, especially for professional streamers. And so in the chapter that I wrote, I'm trying to address this research gap by focusing on three main sub-questions. So first, I look at whether the monetization agreements, so whether we are talking about an affiliate agreement or a partnership agreement, so whether these agreements that are concluded between Twitch and its professional streamers could legally qualify as a work contract under French law. And to answer this question, I followed a judgment from the Cour de Cassation, according to which three elements must be fulfilled for an agreement to be considered as a work contract in France. So first, there must be a provision of a service. Second, you need a remuneration element. And third, there must be a subordination link, in this case, between the platform and the streamers. And without going too much into the details, I argue in the chapter that those three elements are fulfilled when an affiliate or partnership contract is concluded between a streamer and Twitch. So second, I look at this concept of platform discretion, and I look at how it actually evolved within the legal and contractual framework of content moderation. So essentially, I explain how the principle of contractual freedom allows online platforms to provide their digital services based on rules that they have drafted themselves, so the so-called terms and conditions that we all know of, in which platforms grant themselves enormous power and full discretion to moderate content online. And in this context, I define a platform discretion as the power granted to and by online platforms to formulate and enforce the rules governing their contractual relationship with users. And then finally, I also take a close look at the actual harms that can arise when Twitch suddenly and unilaterally cuts off a creator's ability to earn a living on the platform, of course, at its own discretion. And to do that, I collected data from 10 semi-structured interviews that I conducted with streamers located in France, So I just want to thank them. I know that none of them is here, but I really want to thank them because I learned so much and they took the time to talk to me and to also really, yeah, be vulnerable in front of me. And I think that this was a very nice experience beyond the fact that it also allowed me to write a book chapter. And so I conducted those interviews with those streamers located in France who got banned from Twitch, either permanently or for a short period. And so based on this data, I have classified the harms arising from platform discretion into two distinct category of harms. So first, we have the material harms, and then we have the second category that is the immaterial harms arising from platform discretion. If we focus on the material harms, so the first one is, of course, the financial instability and the economic loss that these professional streamers suffered when their accounts got shut down. A second material harm is the prohibition to stream on another platform. So when these professional streamers signed their agreement with Twitch, those agreements used to have, I don't think it's the case anymore, but they used to have a content exclusivity clause that would forbid creators from streaming somewhere else. So the only thing is that the duration of a ban sometimes was not very clear. And so some streamers did not want to take the risk to stream on YouTube, for instance, fearing that this might lead to a longer ban from Twitch. The third material harm arising from platform discretion is a decline in the number of subscribers that streamers have experienced after getting banned, which in turn impacted their reputation. However, some of them said that despite experiencing a decrease in their subscription numbers, some of them said that they were actually very nicely welcomed by their audience when they got back on the platform, and they actually received a lot of donations from their audience. When it comes to the immaterial harms arising from platform discretion, streamers reported experiencing emotional distress and a lot of stress, anger, and sadness. A streamer said, and I quote, Twitch has limitless and absolute power over us, which is a terrifying feeling. It is a chilling authority where a single click can shatter livelihoods and dreams. And I consider this situation as a form of modern slavery. So very, very strong words. Another immaterial harm was the cyberbullying that streamers have experienced after getting banned from the platform. Another harm was the loss of spontaneity, self-restraint, and censorship. So streamers unanimously agreed that the most effective approach to fight the stress that they had because of platform discretion, they had to self-censor themselves, essentially. And so one of them even said that Twitch became a dictatorship where you cannot say anything anymore. Another harm was the loss of spontaneity, authenticity, and sincerity of streamers. And finally, the last immaterial harm identified in the context of platform discretion is what I referred to as the Americanization of streamers. So as I said, I've only interviewed streamers located in France, which was actually quite interesting because some of them said that they felt forced to Americanize themselves in order to please a platform and to fit within what Twitch would consider appropriate content. And one of them said, I quote once more, if we want to continue our career as professional streamers on Twitch, we are pushed to embrace American culture or even to become American. It is a challenging task, considering that French values and norms can significantly differ from the American one. So now moving on, the question is, how can we ensure that the digital labor of streamers is not just profitable for platforms, but also sustainable and fair for those who contribute to the success of platforms, so namely streamers themselves? One step to address this issue would be to recognize Twitch partners and affiliates as actual workers of the platform, which would in turn give them access to unemployment benefits and protection if their account gets suspended. So in France, there was this French influencer law, which I used to be obsessed with, and which was adopted a couple of years ago. And this law could have been the perfect chance to actually make that happen, to protect to better protect streamers. So this law brings new rules for influencers, new obligations, and some of those rules are supposedly supposed to protect influencers a little bit better and to make their legal status a little bit more clear. So this law, for instance, talks about the relationship between an influencer and an influencer agent, but it completely ignored something huge, that is the relationship between creators and the platform itself. So yeah, this is that was it for my presentation. Right now, as we speak in France, streamers and content creators have almost no legal ground to fight back the power that platforms have in content moderation. And my fear is that this power keeps on growing with time. But yeah, thank you so much. And I cannot wait to hear your thoughts.
Thank you, Laura. Amazing. And but I guess a bleak note to end on, and I fear Malcolm's contribution perhaps will echo some of what you've raised around the lack of protections afforded to influencers, particularly in their relationship with the platform. But we will wait a moment before we discuss your very interesting work, and instead I would like to ask Malcolm Katrak, who is assistant professor at Jindal Global Law School at Jindal Global University in India and a York Fellow at the Osgood Hall Law School at York University in Canada, who co-authored a chapter, The Regulation of Influencer Labour in India, situating a novel form of labour amidst colonial continuities of informality, with Shardool Kulkarni, who is the thesis program candidate at the Bookman Faculty of Law at Tel Aviv University and a teaching associate at the Symbiosis Law School, Noida, in India. So, Malcolm, I would love to hand over to you.
Oh, thank you so much. I mean, amazing presentation, Laura, as well. I'm just gonna share my screen. I hope this works. All right, so I guess it's visible, right? I'm audible as well. So yeah, so firstly I'd like to thank Professor Kumar, his paper was actually quite, I mean, his paper with Professor Tusu was quite influential in this idea of what happened post TikTok as well. So thank you so much for getting us discussed it. So the idea of writing for this book chapter as well actually followed not from my research on influential labor, which was actually quite nascent. It followed from my research on platform economy, which I was doing under Professor Valeria De Stefano at Osgood Law School. And so I would also want to thank Professor De Stefano, Professor Sarah Slynn, and Professor Hannah Johnston, and Professor Penny, who are at Osgood Law School, who were basically the impetus for both Shardool and I to actually conduct this research. Now, as a lot of authors in the book chapters in the book have mentioned, that there is that sort of similarity between the platform economy, especially digital labor platforms, and the influencer labor, and a lot of it was a lot of the protections also supplement that as well. In our chapter, we basically argue, we don't necessarily go into the employer-employee relationship. I think there are other book chapters, especially the previous edition of this, of Catalina and Sophia Ranchoda's, David Mangan's chapter is actually quite interesting on tackling the employer-employee relationship, as well as Laura's chapter as well. So we don't necessarily go into that to, put forth the idea of a work contract. Of course, that could be a future research as well. But we necessarily identify why there is a need for India to ratify certain conventions, especially the ILO declaration on ILO DFPRW principles. So most of the conventions like collective bargaining or occupational health and safety, and so on and so forth. So firstly, why India, right? India has the second highest number of internet users. It has the largest user base for Instagram, YouTube, Facebook, WhatsApp, and at a point of time, a very large user base for TikTok as well before it was banned in 2020 with the clashes. The Indian influencer marketing industry, while is quite small as compared to the global north jurisdictions as of now, but it's rising, and the estimates assume that it's going to rise to $350 million. And this was a report by a private industry, and Forbes had employed another private industry to conduct this. So we don't really have official estimates of influencer marketing industry, but this is what we could find. And as usual, like most of the influencers, whether it's through Reels on Instagram, whether it's through YouTube content, or whether it's through TikTok Reels as well, try to monetize their social media presence. In our book chapter, we specifically also consider Q and Corrigan's Hope Labor aspect, where we analyze why influencers, why would one want to conduct free labor? Why would one want to give free labor in some sense? And we use that concept of hope labor as well. So we argue that, and before I go into how this is connected to influence labor, I think it's necessary to point out what exactly is the Indian setting as such. Now, the Indian setting is quite unique, and it's quite unique to a global south jurisdiction as well, that the Indian labor law essentially was, or in our opinion, is a continuity of the colonial labor laws, right? So earlier during the British colonial regime, you had the Trade Disputes Act, you had the Factories Act, you had the Trade Unions Act. Essentially, those were drafted only for the sake of industrialization and rationalization of the labor. So those were only applied to a minuscule of the workforce that was working in the factories. And that was perhaps less than 2 or 3% of the total population. So people working in mines, people working in plantations, at times people working as slaves as well. At that time, we have a system called zamindari system. So people working under those had absolutely no protection whatsoever through these laws that were drafted. Again, these laws were ostensibly drafted for the sake of having a steady supply of labor in the industries and not for the protection of workmen, right? That got carried on after independence. So India received its independence in 1947. And before that, there was the Industrial Disputes Act that was formed, but let's say a post-colonial regime as well. So what was visible is that there was a formal sector where the laws were essentially applicable. And then there was this large informal sector which had no regulation whatsoever. And that large informal sector basically consisted of ostensible self-employed workers, disguised employment workers, casual labor, so on and so forth. And that informal sector consisted of around 92% of the Indian population, as it is the same thing right now as well. You still have a very large 90% of the workforce that is still in the informal industry. Now, what we construe as informal, and there are different conceptualizations of informal economy and informal labor as well, but in this book chapter, what we construe as informal is the lack of any legal regulation, including employment laws, to the labor force, essentially. So they are essentially governed by contract employment or common law rather than having an employment relationship or labor relationship as such, and therefore labor laws aren't applicable. So India also went through a process of liberalization in 1991. So that sort of informal labor was also visible in the formal sector. So if I had to put it succinctly, you have two bifurcations. You have 8% of the population that is in the formal sector, which has all the rules and regulations, labor laws governing them. And then you have the large 92% informal sector that is not governed by any laws whatsoever. And even if there are certain laws that are applicable, it's only applicable to a few informal workforces, such as contract labor or unorganized workers with minimal social security, and nothing as compared to what the ILO talks about as minimum social security for informal workers in their ILO 2015 convention. So how do we relate to influencer and informality? So the idea again came from digital labor platform work, right? So digital labor platform work was uh, thrusted into informal work under the new labor codes that were drafted, which haven't passed. But we argue that influencers operate amongst the same way because the influencers are essentially vulnerable to platform, and we don't necessarily go into how that is captured. I don't want to necessarily go into how that was captured because Laura has already captured that, and that perhaps applies to other social media platforms as well. So again, they have the opportunity of unilaterally changing their terms of engagement, leaving with no recourse, and most importantly, the algorithmic management that happens on the platform itself. So we do have certain regulations. We don't necessarily have an act that France has ostensibly drafted, as Laura pointed out, but we do have certain regulations. But those regulations essentially put the risk and onus on influencers completely without putting forth anything on the social media platforms. So a couple of them that we've identified in the book chapter is the Advertising Standards Council of India. They've laid down provisions regarding consumer protection, transparency. So the influencer essentially has to disclose whether the advertisement, like who's paid that, etc., on the Instagram handle or the YouTube title page as well. The Central Consumer Protection Authority has tried to ban influencers and heavy penalize them on misleading advertisements. The problem is this has affected small and nano influencers, and small and nano influencers are those below 100,000 followers on Instagram, let's say hypothetically. And we use the same definition that Professor Catalina Guanta has mentioned regarding small and nano influencers as well. And that is, unfortunately, they are the ones that are really affected, and the penalties are drastically high. It's around 1 million rupees, which is really high for small and nano influencers. So what we witness is a shift of risk onto influencers without actually according them any rights whatsoever. Now we come to the TikTok ban. So again, I think this is quite interesting, especially in the wake of what happened in the US a month ago. India was amongst the first ones to ban TikTok, again, on the basis of this idea of techno-nationalism, but also the idea of how there was this military clash and China was using certain applications to surveil the Indian to surveil the Indian population as well. Professor Kumar and Professor Thusu have actually pointed out how there was this idea of nationalism that came in as well, which we don't necessarily go into. But TikTok ban in India is important because TikTok was essentially hailed as an equalizer app as compared to Instagram. So it was always on it's either Instagram and YouTube versus TikTok. So TikTok was an equalizer application because it mainly consisted of content creators from the lower caste and lower class background in India. So people from Dalit, Adivasis, minorities were mainly people who were creating content on TikTok, as compared to Instagram, who had mostly an upper class or upper caste foundation, and which still does, right? So when the ban happened, you had 150 million active users who were working class influencers on TikTok who lost their monetization completely. And when these influencers, especially from the lower caste and lower class, tried to move to Instagram, they weren't able to monetize Instagram in the same way that they were able to monetize TikTok. And so there you could see the labor struggles that most of these influencers went through. Yeah, so then we come to the fundamental rights and influencer labor. Now, India has, as most of you might know, so the ILO Declaration on the Fundamental Rights at Work recognizes certain categories of labor standards that are applicable to all workers more generally. So it doesn't matter whether they are self-employed, it doesn't matter whether they are under contract labor, disguised work employment, whatever categories you want, non-standard forms of work, they're generally applicable to all of them. So even in workers in the informal economy ought to have the ILO convention, ILO rights at work. So all of these 11, so there are 11 fundamental instruments, 10 conventions, 1 protocol, and India has ratified only 6 of them. Now, ratification doesn't necessarily mean India has actually laid down in the law, because as Professor Kamala Sankaran points out, that even the ones that are ratified, either through legislation or through constitutional provisions, have exceptions or caveats to them. So, for instance, freedom of association is mentioned as an article under Article 19(1)(c), which is a fundamental right, but that's only applicable if you form a union, and it's only applicable to a certain workforce, right? Which does not include self-employed workers, because Competition Act would be applicable to them, would apply to them, right? Prohibition of discrimination is a constitutional right, but we don't really have an anti-discrimination statute, so it only applies to state actors in some sense. Again, prohibition of child labor only applies in hazardous industries. So in the ambit of child labor, you have certain exceptions for entertainment purposes. So influencer or kidfluencers are basically captured within that, and therefore you don't really, so therefore their labor is not counted as child labor. And again, with respect to forced labor as well. So we note that rather than engaging in the debates of employer-employee relationship, or whether they are captured by the Industrial Disputes Act or the Unorganized Workers Act and so on and so forth, what we want to do is we want to impine upon the government that, or the regulatory authority more generally, that there is a need to ratify all the 11 fundamental instruments of the ILO DFPRW, because they are generally more granted. And then you can, of course, as and when it proceeds, you can, of course, engage in the employer-employee debates between the platforms, between the platform and the content creator. So again, as I mentioned, discrimination, because we don't really have an anti-discrimination statute. Occupational health and safety is largely sectoral, so it doesn't apply to mostly informal sector workforce. Collective bargaining, again, does not apply as well. And on the left, you see a photo. So that's a photo of a queer influencer from Ujjain in India, who committed suicide at the age of 16. So their name was Pranshu. He was a queer. They were a queer influencer. And they received death threats and rape threats as well. And this is, so apart from the platform economy perspective, like, we really wanted to include this story in the book chapter, because I think it really captures the set of our problems and what most of the people have to go through on these platforms. So in the end, we provided a couple of suggestions. Of course, the ILO DFPRW ought to be applied to everyone more generally, as long as it's counted as work, including self-employed workers, if there is any sort of if there is any sort of relationship in any way whatsoever. Again, there is a need to develop a regulatory framework, because influencers face different challenges as compared to platform work as well, but nonetheless, you'd still have to develop a framework. And the last thing we wanted to identify, which we haven't really elaborated much in the book chapter due to the condensity of words, but what we wanted to do is that we wanted to identify that there are certain socioeconomic ideals, right, that are enshrined in what may be termed as the director principles of state policy. So they're not justiciable. So I can't go to the court and say that, hey, I have these socioeconomic rights or labor rights, and therefore they are enforceable. So they're not enforceable as fundamental rights would, but you still have mostly labor law protections under these articles, which, if the Supreme Court wanted, could be applicable more generally, or the legislature perhaps could make sure that these ideals are realized in a meaningful way. So while you have civil and political rights that are considered fundamental rights, you still have socioeconomic ideals, and they're not rights as such. And therefore, these labor rights, which include prohibition of, which includes issues containing occupational health and safety, issues containing collective bargaining, etc., so on and so forth. So these ideals ought to be realized moving from the directive principles to the fundamental rights or through legislation. So yeah, so that's basically our argument, and we look forward to the discussion and any other questions. Thank you so much.
Thank you so very much. And I'm sure we'll get onto this shortly, but so interesting to think about how thinking about the influencer and their protections allows us to, in the Indian context, to both think about the like broader issues of labor in the context, as well as the kind of specificities of what's happening with influencers. So thank you. We will now transition to hearing responses from our two discussants. The first one comes from Colton Meister, who unfortunately has sent his apologies because he's been struck by a flu overnight. But despite not being able to be here, and he was very upset that he couldn't be, he has sent me through the notes that he's made. So I'm going to do my best to represent them for you, Laura, and to read out some thoughts that he had after reading your chapter. And then I would love to hand the floor over to Anilish Kumar, who is assistant professor at the Beijing Normal University and Hong Kong Baptist University. So let me just find the document that Colton has sent. One moment. Okay. And here we are. Okay. So I'm going to read it as he writes it. So the I is obviously not me, it's Colton. I want to thank Laura for her stellar work in putting together this chapter. And also thanks to the organizers for their opportunity to participate in this discussion today. I want to emphasize how incredible this collection is altogether, and especially that it is open access, which is fantastic. I think we can all see how this will shape areas of study for our research, but also produces a massive open access collection to direct our students to read and engage with as well. I want to highlight what I see as 4 generative contributions of Laura's work in this chapter from my vantage point as a researcher in the fields of communication and media studies. Laura's work takes a legal and contractual approach to the understanding of platform power, which is different from my work in media studies in meaningful ways, and I hope to expand on some of these points. So, his first point, interrogating platform power through legal and contractual regimes of visibility. The notion of platform discretion offered by Laura in this chapter presumes enduring power asymmetries that allow Twitch to stipulate terms of agreement in exchange for use. Therefore, we can understand platform discretion as fundamentally an exercise of platform power. In media studies, we talk about regimes of visibility, or the myriad considerations that shape how visible or invisible creators and other media producers are within the constraints of their production culture. I was struck in Laura's work by the notion of legal and contractual regimes and immediately connected these terms in my mind. In other words, what might a law and policy perspective look like for understanding regimes of visibility? Perhaps indeed one answer is Laura's concept of platform discretion. The notion of legal and contractual regimes signal a few things. First, that governance is not imposed, but negotiated, to quote Thomas Poole. Second, it asserts that the reliance on standard contracts, and thus nothing but the standard contract, is also a strategic choice, a maneuver by platform companies. Laura's law and policy approach helps to make this power move explicit on the part of platform companies. Secondly, platform discretion as a source of vulnerability for creators and their communities. Platform discretion as a take it or leave it contract between platforms and all users shapes not only their experiences, but the experiences of audience too, who are equally users on the platform. When a creator's audience amasses on a particular platform like Twitch, the results of an action like deplatforming are deeply felt in their audience community, as it might result in losing a space for social support and leisure. While the conversation has focused on creators for obvious reasons, Laura's chapter helps us to understand how contractual regimes and the power asymmetry of these regimes in the platform economy impact creators as workers, but in some sense, these policies also have secondary consequences for these creators' audience communities, many of whom rely on these creator communities for a variety of social and entertainment needs, and thus become implicated in this process of platform discretion. Thirdly, ownership politics. Has Amazon's Twitch purchase Americanized the platform culture? Laura's work suggests rightly that Amazon's acquisition of Twitch a few years ago has no doubt shaped platform governance, based on what we know from political economists and media. But future research can and should how this Americanization of Twitch is shaped by the legal and contractual regime. The value of this work is clear because it gives us tools to see how law and policy perspectives shape the cultural politics of platforms. And finally, laws addressing influencers and agents, but not platform creator relations. I have argued in my past work on collectives of influencers working or failing to work together in solidarity as workers, and more recently that we need to take seriously the notion of creator-platform relations as a space of negotiation that must be distinct from the relations that platforms assume with all users. Creators are a distinct class of workers, as I and many of us continue to argue in our work, and must be treated as such under the legal and contractual regimes. Laura discusses the failure of limited existing law and policy to address influences beyond an agency and agent-creator perspective. What about contractual regulation for creators and platforms? Future research can and should engage with this inquiry. As I hinted at the beginning, Laura's work can help bridge calls for creator solidarities across my fields of communication and media studies, along with the fields represented in #Hustle, such as internet and consumer law and policy. Both fields can continue to use their areas of expertise and analysis to advocate for creator solidarities on Twitch, and certainly far beyond Twitch, widely across the creator economy. And to conclude, thank you again, Laura, for this important and timely work, and I invite you all to continue thinking with us about these issues that Laura presents in her chapter. So, Laura, I'll give you a minute to digest that very thoughtful response from Colton, and now I would love to hand over to Annelish.
All right, thank you very much. It is a privilege to be here, and it's an honor to hear your presentations, and I really enjoyed Laura's presentation too. I must honestly confess, I mean, we are talking about labor, and I'm in China at the moment, and there's a lot of discussion around artificial intelligence, and DeepSeek has already caused a lot of discussion around the world. And people are increasingly using ChatGPT and DeepSeek. So in that era, I must say that I have done some manual labor. I actually downloaded it and read your paper. It's not just, so there is actual manual labor that has gone into it. I would like to start by congratulating the authors. It's a fantastic piece of work. I must also very honestly share that before joining academia, I was working as a journalist. And since I'm no longer a journalist, I do not have the privilege of being an expert overnight. So I do not claim that I understand everything about law. My understanding of the topic is limited. And I really learned a lot from your paper. So thank you very much for that. It's very, very important for a country like India, where unfortunately informality is the formality, or being informal is the formal. Lack of system is the system. So thank you very much for this eye-opening chapter that you have written. I must also start by saying that works like these really make us rethink about the importance of book chapters. I'm digressing a little bit because institutions as these days they're going so crazy about journal articles, but then you come across book chapters like this, and they are amazing contributions because they simply shape our understanding of the topic. So thank you again for reinforcing our belief in the idea of writing books and writing book chapters. So thank you for that. Now, as I said in the beginning, I'm not an expert on the topic. So my questions are going to be like an average reader. And please do not misunderstand them. Please don't think that I have any sort of vested interest in maintaining the reproduction of informality, as you call it in your paper. So one of the things I was thinking is, because this whole field is about immaterial labor, right? So and it has this freedom of expression, some artistic expression. So I was struggling to understand whether regulatory frameworks would be good enough to provide any solution. Now, on the last page, I very clearly remember, because you say laws and regulations are not an issue in India, they're very much there. But because the system is such that they're designed in a way, or they have continued for many, many years and decades to help those in power rather than those who need actual help. But still, because there's a lot of discussion around regulatory frameworks. So first question is, to what extent it would be realistic to expect regulatory frameworks to have any role in providing any solution to a field which is largely immaterial labor? So that's first. Um, and second is something which I think of when there was a lot of discussion around Uber in many parts of the world, the relationship between the driver and Uber, and what kind of relationship should be there, whether they should be considered as a full-time employee of Uber or not. And I thought we can draw similar parallels here and understand whether these people who are social media influencers, whether it would be reasonable to expect them to be full-time employees of platforms. Because it would be difficult. The third thing is that the sense I got from the chapter, or maybe I'm wrong, is that somewhere you treat this whole field as traditional entrepreneurship. And why would you do that? Is it not different from traditional entrepreneurship? So these are the first three questions I have. I have many more, but I would be very, very delighted to hear on this.
Thank you. Thank you so very much. I would love to invite Laura and Malcolm to begin the discussion, and whether you have thoughts in response to that before we open it up.
I was going to say, perhaps Malcolm, you want to reply directly to the questions, and then I can just also very briefly address what Colton has said.
Oh yeah, certainly. I mean, yeah, these are tough questions. Thanks so much. It makes me think a lot as well. And so we were you're completely right. Like there is a regulatory framework that's there, and that hasn't been used in any way. And whether it's possible to have that sort of, whether it's idealistic in some sense to have that sort of impetus on the legislature to actually draft a regulatory framework as such, when that hasn't been the case more generally, and that hasn't been used. We were grappling with that, and which is why we did not really suggest. So our earlier argument, Shardool and I were having this discussion as well, whether we should prove that these content creators could be counted as employees, or more broadly in the Indian context, workmen under the Industrial Disputes Act. And we thought that wouldn't fly because, of course, even digital labor platform workers haven't been classified as workmen yet and have been trusted in the informal economy. So we didn't want to take over the regulatory route. But what we wanted to identify is that there is a sort of hypocrisy in some sense in the Indian, and that's not any political party per se. In fact, I would say the left has, or central left has perhaps done that, in fact, more than the far right regime that we have right now. But there is this sort of hypocrisy that's there, where we have gone to the global north, and especially at the ILO, and stated that we've ratified certain treaties and enshrined them within our constitution, or whether through laws. And there are these caveats and exceptions that we wanted to point out. Now, whether that actually would play a role in some sense, we're not sure. In fact, I would think that given the current climate right now in India, I don't think our proposal perhaps would go anywhere, to be honest. Sadly so. I mean, I suppose Professor Kumar would concur. I'm not sure, but I don't think our proposals in any way would go forward, which is why we wanted to identify the directive principles. We also wanted to provide an avenue to the court to say that, yes, there are these directive principles that are enshrined within the Constitution, which, though non-justiciable, if they could be read as socio-economic rights with civil and political rights. So let's say, for instance, our right to life could be read as right to providing clean environment or health and safety. So if those socio-economic ideals within the directive principles, which are already regulations, could be read in conjunction with fundamental rights, the court could perhaps take the mantle instead of the legislature. Now, we haven't really broadened that argument because most of our argument was that the legislature ought to take the ILO principles into account. But you're completely right. Whether a regulatory framework as such would be useful, we're not. I mean, it is. It is certainly, of course, idealistic, and I suppose my co-author would agree with that as well. But we can only hope. I can only hope that that happens. Um, I can answer the other two as well, but unless Laura wants to take over, and then maybe I can like answer the other two questions.
So should I reply to Colton's remarks?
I mean, if there are things that come to mind that you want to bring up, or if you would like to move on to seeing if there are other questions.
Yeah, I mean,
it's your space.
No, I mean, there are a couple of things that I've heard. I mean, throughout Malcolm's presentation, which I very much enjoyed as well, through Colton's comments and also through Annie Lesh's remarks. So we heard a lot about this, like a union of workers that could, like be something that could help, for instance, influencers when it comes to their rights. I wanted to say, so I'm a little bit more familiar with the French context. So after the adoption of this law that I mentioned, so in 2023, there was a union that was created, and I was actually checking now what this union was doing because I haven't been very much in touch with their work. And actually, the only thing that this union of influencers is doing is to educate influencers on their obligations. However, it doesn't seem, at least from the website, that they are promoting or like trying to advocate for better protections for influencers. So that was one point that I wanted to say. So not very much convinced by the work that this union is doing, at least in France. When it comes to the harms also caused to the audience and to viewers, this is a point that I very much agree with, and yeah, I find it very, very interesting. I'm not sure if any research has been done on the impact of audiences and viewers and followers when like one of their favorite streamers has been banned, for instance. To my understanding, when I conducted the interviews, streamers have a very, very specific and peculiar relationship with their audience, and apparently also based on what they told me, viewers will only follow a couple of streamers. So it means that when one of them would get banned, they were extremely sad and they were trying to reach out to them. However, it was quite hard because then they couldn't really stream on any other platform. Something else that I wanted to mention very quickly is that in the meantime, so it was, I think it happened after I conducted the interviews. So there is this live streaming platform that is called Kik, and that is like apparently like the direct competitor to Twitch. And I know that, for instance, what Kik is doing is that they are paying streamers per hour. So for instance, they will stream 1 hour and then they will get $16. And I do think that the contractual relationship that streamers have with Kik was much, much better in terms of protection than the one that Twitch was providing to its streamers. So the law, of course, I mean, the law, of course, could be amended. The law could do much better when it comes to providing protection to streamers, but also platforms themselves, as we discussed throughout this webinar. And thank you so much, Colton, for your remarks. And I hope that you will feel better very soon.
So sorry, but Professor Kumar, can I take the other two? But like, if you had follow up. Yeah, so the other two comments, I think you're right. In the Uber and employees, we weren't really sure. So Shardool and I were again discussing about this. We weren't really sure whether we wanted to compare that to digital labor platforms. Primarily because digital labor platforms, and again, I can divide it within web-based platforms and location-based. So I'm considering the location-based platforms here. It's relatively easy, in our opinion, to actually prove a sort of subordination domination relationship in this sort of labor platform, especially like location based. It is perhaps a bit difficult to prove that sort of domination, or those four-factor multi-factor tests which are generally applicable in the influencer space, and which is why we would love to advocate for her, perhaps employer-employee relationship, and thereby they're captured by the work, by the, let's say, the regulatory regime. But we refrain from arguing that predominantly because of the difficulty of capturing this sort of subordination and domination relationship. But I think, I suppose the arguments that Laura's made could certainly be supplanted to the Indian regime as well. And finally, you're right. Like I don't, I'm not sure what the perhaps media studies, cultural studies have a different view on it, but I'm not sure if we can think of, from a legal regime, I certainly think from a traditional traditional employer-employee relationship perspective. We don't necessarily think of it from an entrepreneurship perspective, predominantly because if it's an entrepreneur, and if you categorize someone as entrepreneur, they become a self-employed worker, which means that as soon as they become a self-employed worker, none of the labor rights would be applicable to them. And therefore, we don't want to consider it from a traditional entrepreneurship perspective. We, in fact, want to point out the precarity that the that the content creators or platform workers face, and how much control algorithmically platforms have on these content creators.
So, thank you very much for that. I mean, I must again start by saying that you use the idea of hope labor in your paper, and the hope that you have in relation to India, I must start calling you hope scholars, because you really have a lot of hope about it. So thank you for that. Actually, what Laura was saying, it reminded me of a few things when she talked about the role of audience and the role of sort of loyal viewership or loyal followers. I have seen on a couple of occasions when people would have been, say, their account would have been suspended on Twitter, and then there would be a massive outrage on Twitter saying, bring back X or bring back Y, and then their accounts have been reinstated. So I think maybe there is a certain role that audiences can play or followers can play. That's one thing. The second thing, in the Indian context, or maybe in other contexts, is that when the state itself wants to suspend your account, so it's not always the platforms who have the final authority. I mean, of course, there are platforms, they have the authority to suspend technically, but at times we have seen people who are not necessarily sympathetic to the ideology or views of those in power. Their accounts will be suspended because there would be something going to their office from the Prime Minister's office or Home Ministry, and they have to just comply. I mean, somebody who is as precarious as Elon Musk, who said, we have to survive in Indian context, so we cannot be saving your freedom of expression and so on. So I was wondering if there's any view on that. What happens if the state itself wants to suspend your account? And the third was about the role of, at this point of time, it's a good time, especially in India, for influencers, because if you have a certain political ideology, or if you're sympathetic to those who are in power, or if you're creating content which sells the idea of civilization and history and nationalism, then you have chances to thrive. And I was wondering if the authors have given a thought from this perspective, like what kind of content should you be doing to be able to survive? Has it got any relationship to do with the regimes you're working in?
Should I? Yeah, no, that's an interesting question. I mean, I feel like if this recording goes out, maybe I'd be banned from all social media platforms. Thankfully, I'm in Canada, so that wouldn't affect me. But yeah.
Sorry, Malcolm. Sorry, Malcolm. Sorry to interrupt. I am in China, so I'll be in more danger. I'll be labeled as anti-national the moment this video goes out.
No, that I mean yeah, you're right. To answer your first question, I mean it's difficult. It is difficult when the state has or usurps this power. So in the Indian context right now, with I mean, for the others, there is this show that was India's Got Latent, and right now you have influencers being targeted because of something they said, which which some consider borderline um um borderline pornographic material in some sense, that or pornographic statements, and that's why a lot of politicians are jumping on the bandwagon right now to ban a lot of these influencers who are part of this show, having millions of followers, right? So and among them chiefly is the state. So in India, the state actually wants to ostensibly pass the digital broadcasting bill, which allows the state to usurp the control of almost all the platforms and pressurize the platforms to actually ban certain accounts that do not follow this sort of, especially the nationalistic agenda that the current government is trying to propagate. Apart from the constitutional provisions, there is absolutely nothing that stops the state from doing that right now. Sadly so. And we haven't really taken the state into account, and we wanted to perhaps identify the TikTok ban as what the consequences would be on the influencers more than what the suggestions could be. And it is this something perhaps we could look at, but this is certainly an important point, and I know this follows from your and Thusu's paper as well regarding the sort of nationalism that's arising in this context as well. Yeah, and you're right in the sense that the audience plays an important role. The public does play an important role as well. Again, we haven't necessarily pointed that out in the chapter, but this is something that we could certainly research for sure. And thank you so much.
And I think that thinking about the role of the audience speaks really nicely to some of the work that I know that Blake has been doing in CJ, who just had to dash around, yeah, how this kind of ongoing negotiation of governance and kind of the role of the call out in trying to do some of this accountability, but I guess not so much directed necessarily at legal regimes. So just thought that was an interesting connection to it. Oh, Blake, please.
Thank you for the mention of that. And I just wanted to say thank you to the presenters. I very much enjoyed the webinar and have to run, but wanted to congratulate you all on an excellent edited collection that I definitely plan to engage in with my work moving forward.
Thank you so much for joining us.
My pleasure. Bye.
And I think, being mindful of time, I'm sure we could continue to discuss this for many more minutes and hours, because these things are so consequential and matter. And I think, yeah, really interesting to think about, Malcolm, what you raise about who's affected by this kind of informal labor. And I think certainly resonates with what you're saying, Laura. I know from what you've talked about in terms of the French labor, the French influencer bill, and who was being targeted by that, and this role of class or the imagination of who is an influencer, and how we think as a society they should be protected to do this kind of work. Could have been an interesting thing to explore, but I think we might have to end it there. So I just want to thank you all so much for your work and for your contributions, and yeah, hopefully we can continue discussing this.
Thank you, and all the best to everyone.
Thank you so much.
Thank you so much, Professor, for all the comments. Thank you so much, Katalina. Thanks, Taylor.
If I had sounded sleepy, apologies for that. It's 11 in China, so I'm sorry about
Thank you so much for making the
you.
time.
Thank you. Thank you.
Bye.
Bye bye.
Bye.
Thank you.